Hi, my name is Rachel. I'm a solicitor in the corporate commercial team here at Russell-Cooke. This is the next in our series of the Legal Guide for Startups, and I'm going to be talking briefly about employees and consultants. Obviously, if you've seen any of the other episodes, we have covered different aspects of startups, and there's more to come. But it goes without saying that having the right people and the right skills in your business is going to be absolutely crucial to long-term success. As you may know, if you've seen any other episodes in this series, we've been looking at a fictional client called Gina and her new tech startup company called Streamzer. We'll come back to them in a couple of minutes. Businesses obviously go through different phases. Often in the early stages, you might have people providing services or skills or somehow getting involved in the development of the company without any pay or any sort of formal reward. This happens all the time, and we hear, for example, lots about IT people who get involved in development of projects at early stages. Having said that, there will often come a time where it looks like the company is going to be sustainable longer term, and it's therefore appropriate to start documenting people as either employees or consultants. This might be bringing new people in, or, as is really commonly the case, simply documenting what's actually already happening. It is worth noting that founders often forget to do this for themselves. So if you're going through this process of documenting your employees or consultants or whatever they might be, make sure that you cover this off for yourselves as well. It's also worth pointing out, perhaps an obvious point though, that you get your employees and consultants agreements sorted out now, but of course this is going to change over time. It's a constantly evolving scenario, so it's never going to be set in stone, and you will need to be revisiting this from time to time, be it when people leave, people come in, whatever it might be, but it is going to be a constantly evolving situation. As for why you should have written employment contracts, you can still be an employee without a written agreement. This is always a question of fact, but it does provide clarity to everybody, both the company and the employee, if you put this in writing. And there is also, where somebody is an employee, there's a legal obligation on the employer to provide certain details in writing, and this is referred to as a statement of particulars. Having these structures in place can also be a really important tool for attracting new staff in, new employees in, and it may also be useful in attracting new investment. We'd recommend that if you are going through this process, that you also take the opportunity to put in place some good basic minimum workplace policies covering things like discrimination, sexual harassment, and so on. Turning very quickly to the distinction between an employee and a consultant. An employee is someone who provides services under a contract of service to the company, whereas a consultant works under a contract for services and is much more likely to be doing that on their own account through a company of their own. They're going to be able to pick and choose the work they want to do, perhaps get involved certainly just on specific projects or work streams or whatever it might be. In terms of whether somebody's an employee, this is often referred to as a test of control. Are you obliged to offer work to that person? And if you do offer work, are they obliged to do it? And if so, how much control do you have over how and when that work is carried out? I would always say that if there's any doubt as to whether somebody's an employee or a consultant, that you do go and get some specific legal advice. There are certain minimum standards which an employee is entitled to by law. These include things like the minimum wage, obviously, certain amounts of holiday pay, statutory sick pay, maternity and paternity leave rights, and so on. There's absolutely nothing to say you can't go over and above those statutory minima. And this is often done, for example, statutory sick pay, which in reality is really quite low. And often when companies can afford it, they will offer a discretionary period of sick pay at full salary. Other terms that the contract's likely to cover include obviously job title, salary, responsibilities, who they report to, hours of work, quite a big one at the moment. You'll probably find that people are going to be looking for some flexibility, both in terms of the hours they work and where they do it. This was already happening, but of course lockdowns really accelerated that process, and you may well find that people are no longer willing to work a full 5 days from the office even once they can. Once you've got the content of the agreement sorted out, it is worth remembering to sign and date them. It sounds really obvious, but you'd be amazed how often we come to sell businesses and they've been agreed, shoved in a drawer, and never been signed or dated. It's not the end of the world, but it really is worth making sure that gets tidied up. Turning to consultants or contractors, as I said, these are people who provide work on their own account. They may do so through a different company of their own. Nonetheless, it is worth having documented structures in place. You'll want to know how much people are going to be paid for specific bits of work, how many hours they're supposed to devote to it, what the deadlines are. And very importantly, with a consultant, Any IP that they develop in the course of doing work for you is not automatically going to belong to the company. It belongs to the consultant, unless you've put in writing that it belongs to the client. With an employee, this happens as a matter of law. What they do, the IP they develop at work belongs to you, but that's not the case with consultants. So really worth documenting, if for no other reason than that. To turn to the company we've been advising in previous episodes of this, which is Gina and Hans, who are directors and shareholders of Streamzer. They've been working away in this business for a while now without taking any salary, as is often the case, or any holiday pay or anything like that. It now looks like the business is going to be sustainable long term, so it's probably appropriate for them to put in place employments of contract for themselves and for any other employees in the business as well. In terms of Hans and Gina, this might well be labelled a director service agreement, but really it's just an employment contract for directors. It's just a different name, but ultimately it's the same thing. Where it looks like others are going to stay on longer term, or indeed they're bringing in new people, they should also put employment contracts in place. Where possible, it is a good idea to try and keep employment contracts reasonably standard across employees. Obviously, they're going to have some different terms, their salaries will change, job titles and so on. But to the extent you can, if they're all based on a similar template, that's going to be helpful to you longer term. In terms of practical points, Gina and Hans will need somebody to actually prepare the agreements for them. As startups, they may not have internal resources available to do that, so you could ask solicitors such as us. You might have some outsourced HR services. That's not uncommon, the likes of Peninsula and so on. HMRC and .gov.uk websites have quite a lot of useful information for setting up people as employees or paying consultants. And of course, you'll need to arrange somebody to actually do the payroll services. There are lots of packages out there that mean you can do this internally, but you do need to make sure, be it internal or external services, that people are getting paid properly, and very importantly, that PAYE income tax and national insurance contributions are being paid, along with any pension contributions. Just as one very final thought, we often get asked about unpaid interns. As tempting as unpaid free labour might be, the bottom line is that if anybody is really adding value or contributing value to your company, they are entitled to the national minimum or living wage. So you need to make sure that you're following that up properly. The next in the series is going to be about intellectual property matters, so please do keep an eye out for that.